How does a bill turn into law? So when does a bill truly turn into law? People may be confused over this particular topic of interest and the difference between a bill and a law, but in reality this is actually quite simple. But first, before that, we must identify the distinction between a bill and the law. A law is, as defined by Natura, is a rule of conduct, just and obligatory, promulgated by legitimate authority for the common good and benefit, while a bill is, as defined by De Leon, is a proposed law submitted to the Congress for its consideration. In short, a bill is a proposed law, while a law is a bill that has been approved and enacted. Now, we can find the process of a bill turning into law by the certain provisions stated in Article 27, Section 6 of the 1987 Constitution, stating that the bill may turn into law through the following. Letter A. When the President approves a bill presented to him and signs it. As stated, every bill passed by the Congress shall, before it becomes a law, be presented to the President. If he approves the same, he shall sign it. Otherwise, he shall veto it and return the same with his objections to the House where it originated, which shall enter the objections at large in its journal and proceed to reconsider it. Letter B. When the presidential veto is reconsidered by 2/3 of all the members of both houses voting separately. As stated, if after such reconsideration, 2/3 of all the members of such house shall agree to pass the bill, it shall be sent, together with the objections, to the other house, by which it shall likewise be reconsidered. And if approved by the 2/3 of all the members of that house, it shall become a law. In all such cases, the votes of each house shall be determined by the yeas or nays, and the names of the members voting for or against shall be entered in its journal. Letter C. When the President fails to communicate his veto of any bill to the House where it originated within 30 days after receipt. The President shall communicate his veto of any bill to the House where it originated within 30 days after the date of receipt thereof, otherwise it shall become a law as if he had signed it. D. No pocket veto. The pocket veto is an implied form of veto wherein the President does not act on a bill within the 30-day period prescribed by the Constitution, not explicitly recognized but in rulings. Article 6, Section 27 of the 1987 Constitution states that if Congress adjourns before the President can act on a bill within 30 days and he does not sign it, the bill does not become law. E. No partial veto. Paragraph 2 states that the President shall have the power to veto any particular item or items in an appropriation, revenue, or tariff bill, but the veto shall not affect the item or items to which the bill does not object. And lastly, letter F, legislative veto. A legislative veto is when Congress tries to block or reverse executive actions without passing a new law, but in the Philippines, it's not allowed because it violates the separation of power. A congressional veto is subject to serious questions involving the principle of separation of powers. That's all.